Okay, hello everyone. I'm Sammanika, the head of placements at LawSikho. And as most of you know, in law schools and outside law school, there is a constant debate which goes on about whether the death penalty in India should be abolished or not. So today I have a very special guest with me to talk about this issue. Sir is the very famous defense lawyer from Bombay. And Samyukhtha will give the brief introduction about Sir. And then Sir will be sharing with you about his knowledge and insights. What is the main jurisprudence behind death penalty? So over to you, Samyukta, and then we'll hand over the mic to Sir without wasting any further time.
Hi everyone, let me just introduce Mr. Aniket. He is a practicing counsel at the Bombay High Court and an expert in criminal law. He has appeared in several interesting judgments such as defending the Ministry of Defense in the Adarsh housing scam, securing an acquittal from the High Court for a double murder case where there was a death sentence, and securing an anticipatory bail for actor Shilpa Shetty. Further, he has appeared in several other judgments which we may be interested in. I'm sure we have a lot to learn from you, sir. Over to you.
Thank you, Samyukta, for the generous introduction. Well, good afternoon, everyone. Thank you very much to invite me over on this digital platform. It's my privilege and honor to speak on the platform of LawSikho, as LawSikho is doing an exemplary and noble job of imparting legal knowledge to scores of people. Well, today I'm going to speak on that contested issue of criminal law that has always created a conundrum in the minds of people. We have seen a sharp cleavage of opinion on the issue of death sentence. Some say it should be retained, some say it should be abolished. Today I am going to address you all on the jurisprudence behind the provisions of death sentence, and also perhaps tell you why, in my personal opinion, the retention of this penalty on our statute book is extremely necessary. In Molai versus State of Madhya Pradesh, which is a 1999 Supreme Court judgment, on February 20th, 1996, a 16-year-old girl was preparing for her class 10th examination at her house. The accused persons, who were two in number, took advantage of that situation when they found that she is alone in her house. They barged into her house under some pretext, committed rape on her, and they brutally murdered her thereafter. And then they threw her body in the septic tank. When the case was tried, the Sessions Court convicted them to death sentence, sentenced them to death sentence. High Court confirmed it, and so did the Supreme Court. Similarly, in the case of State of Rajasthan versus Khiraj Ram, which is a 2003 Supreme Court judgment, and the facts are extremely gory. On the night of 10th of October 1992, Khiraj Ram, suspecting infidelity on the part of his wife, Khiraj Ram killed her, also killed his two children and his brother-in-law. The Supreme Court in that case upheld the death sentence awarded by the trial court and noted in its judgment that the murder was committed in a cruel, diabolical manner. The accused did not act on any spur of the moment or any provocation. The murder was deliberately planned and meticulously executed. And after the incident, the accused smoked chillum with calmness, which indicated that he had no remorse, which indicated he had no repentance, which indicated he had no regret of what he did, and he was satisfied with what he had done. The children were done to death in an extremely gruesome manner. Supreme Court in that judgment too confirmed the death sentence awarded by the trial court. In a case arising from Maharashtra, Anjana Bai, accused number 1, Seema Bai, accused number 2, her sister, and Anjana Bai's son-in-law, all were charged for the offense of having kidnapped 15 minor children, and out of them 9 were murdered in extremely brutal manner. The modus operandi of these accused persons was that they were in the business of committing offenses of theft. And in 1990, when Renuka Bai along with her child Ashish had gone to a temple where there was a large gathering, Renuka Bai tried to commit theft over there. She tried to commit an offense and she was caught. And when she was caught and people gathered there, in order to rescue herself from that situation, the child that was with her, her own child, she started slapping him and saying that why would I commit an offense when there is a child, such a child of tender age in my hands? I swear on him I have not committed an offense. And in order to show her bona fides, she started slapping him. The crowd was in tears. The crowd was shocked. The crowd allowed her to let go. When she disclosed this fact to her sister and her mother, they hatched a conspiracy of kidnapping minor children below 5 years of age, to use them as their own children, to commit offenses of theft, and whenever they are caught, to push them ahead as their shield and assault them, beat them in front of people at large, so that people will let them go, thinking that why would a mother assault her own child, without knowing that the child was not actually theirs. That child was one who was kidnapped from their original parents. The Sessions Court at Kolhapur sentenced these women to death. High Court of Bombay confirmed the death sentence. Supreme Court also confirmed the death sentence. Similarly, we all know the incident of gang rape on the night of 16th of December 2012 in the capital of our country, which shook the conscience of our entire nation. Nirbhaya was done to death in a most gruesome manner. The inhuman act of those accused cannot be described in words. Friends, all these were the cases where the Supreme Court had confirmed or upheld the death sentences that was handed over to the accused persons, because of the manner in which the offense was committed, because of the depravity that was shown by the accused persons while committing the offense, and also because there was no possibility of these accused persons having any remorse or any inkling of any reformation in them. All these cases were of extreme cruelty, of extreme depravity, so much so that it would even shame the animals. We have seen incidents of rape followed by a cold-blooded murder of a minor girl, and further followed by disrespect to the body of victim. We have also seen innocent minor children, unarmed persons, helpless women, old and infirm persons who have been killed in a brutal manner by persons in dominating position. And in all such cases, the accused have shown no remorse, or there have been no possibility of their reformation. Where it is established that the accused is a confirmed criminal and has committed murder in a diabolical manner, in extremely inhuman manner, and where it is felt that reformation and rehabilitation of such a person is impossible, it is an unfulfilling reality, and if let free, he would be a menace to the society, our courts have not hesitated to confirm the death sentence. To be or not to be is a Hamlet question, which has been daunting humanity since centuries. The question is to be answered by a person voluntarily on his own. The fabulous majority of humanity would answer the question in favor of to be. The very thin percentage of humanity would answer it in favor of not to be. But what about compulsory death? Obviously, I'm not talking about the murder, but I'm talking about the murderers. I'm talking about legal compulsion which invites death. Obviously, I'm talking about the death penalty prescribed by law. At the outset, I, for one, make it very clear that I am strongly in favor of retention of death penalty. But let me make it very clear that my opinion is not based upon any sense of revenge. My opinion is also not based upon the old philosophy of tooth for a tooth, eye for an eye, hand for a hand, or life for a life. I am conscious that law never likes to take revenge. I am conscious of the fact that tit for tat is not and cannot be the outlook of either law or justice. And therefore, what is the reason to have such kind of provision in law which permits our law to take or extract life from an accused person? It is very essential for us to understand what are the purposes of punishment. And I must reproduce what I think are the 4 primary purposes of punishment. It is all right that everyone agrees that no offense shall go unpunished. And yet, as a student of jurisprudence, we must concentrate on why behind any sentence. Why this one to the exclusion of other is no doubt a matter of reasoning. Why death penalty to the exclusion of the life imprisonment is no doubt a matter of reasoning. However, there are 4 principles of punishment that we must keep in mind when we have to consider this aspect of death penalty or life sentence. The four purposes of punishment are: number 1, deterrent purpose of punishment; number 2, reformative purpose of punishment; number 3, preventive purpose of punishment; and retributive purpose of punishment. Friends, in the deterrent, reformative, and preventive theories, it is always the accused who is alone to be considered by the court, while in the retributive theory, it is the victim of the offense, his or her relatives, and the society in general who are to be kept in mind and are to be considered. When we talk of doing justice to people, we cannot afford to exclude accused person from that class of people to whom justice is to be made. But equally so, we simply cannot forget the victim, his relatives, her relatives, and the society, because all of them are also a part of this criminal justice dispensation system. Justice, mind you, is not only for the criminals, but it is also for the victims. Every cognizable offense is basically against some individual, and yet it is never regarded as a private matter. The reason is, when it is an individual who is the victim of the offense, the state steps in and puts upon itself the burden to prove the fact of commission of an offense against that victim. Deterrent punishment or the deterrent theory has 2 purposes behind it. Number 1, firstly, to act as a deterrent to that very criminal who is sentenced. Number 2, to be a deterrent to all the like-minded people who might get discouraged, who may be put to notice by convictions and sentences of this degree that they should not involve in such kinds of activities. While considering the propriety of and utility of death sentence, Salmon, the father of jurisprudence, had said, "It is better that the snake is out of the world than in it." Salmon was referring to the snakes in the human form. Salmon was referring to the tendency and not to a person. Salmon was referring to the poison and not to a mere bite. Salmon was referring to the consequences and not only to the act. Therefore, in my opinion, what was suggested by Salmon is that the hardened criminals are as poisonous as snakes. They are totally beyond corrections. They are totally beyond repairs. They are totally beyond improvements. They are incorrigible elements. They are not only cold-blooded and cold-hearted, but they are always frozen-hearted and frozen-blooded. And in this context, I am reminded of a Sanskrit couplet: Sarpo dashati kalenaha durjanastu pade pade. It means that snake does not bite often, but a durjan, which means an evil man, an evil person, will bite at every given opportunity. And therefore, Sarpo dashati kalenaha durjanastu pade pade. Therefore, the moment such a snake in the form of a human being escapes, it will show its tendency. It will not forget to bite again. It will not forget to commit an offense again. They may go on costing the lives of innocent people. This is a potential danger to the society, and therefore society is to be protected by awarding deterrent death sentences. Let's take, for example, the case of Kasam, a dreaded terrorist who came to India along with his associates only to kill people mercilessly. He killed more than 160 people in Mumbai along with his associates. Now, to me, he is somebody who doesn't deserve any leniency. To me, he is somebody who has no possibility of any reformation or any correction or any repentance, because even after having committed the offense, his conduct was seen in the courts, which was being watched by everyone in our country, where he was shamelessly giving replies to the questions that were put to him, taking a defense that it was not him who was present at the time of offense, and therefore showing no remorse, showing no regret. Now, such kind of people, such kind of terrorists who causes lives of hundreds of persons in one blast must be necessarily sent out of the world if we do not want to jeopardize the lives of hundreds of other persons. Bad past must be controlled for a good future. Afternoon knows what the morning never suspected. And therefore, if we have to ensure that we have to live peacefully in a society where we are living in, it is very essential that all these kind of people and all these kind of cases, and I'll explain under what circumstances could a court award death sentence and why its retention is necessary in light of what we are seeing in these days. I think mercy should be shown only to deserving people and certainly not to those incorrigible elements who are absolutely poisonous. One can understand if the offense is committed in a fit of rage, or when the accused has shown repentance, or there is no possibility of the accused being a continuing threat to the society. In such cases, death sentence can be commuted, but not in those cases when the offense is rarest of rare. Now, at this juncture, let me also take into consideration the human activist perspective. Generally and quite often, we see that death penalty is criticized as the most undemocratic punishment, which is unsuitable for a progressive and civilized nation. Death sentence is often termed as the most brutal form of punishment. The critics of death penalty often consider it as a method of vengeance and retribution rather than being a punishment per se. Well, these are some common but prominent criticism of death penalty which is often invoked against its retention. Well, the Supreme Court has evolved a test, so to speak, as to under what circumstances could a death penalty be awarded. It is very good for somebody to say that awarding death sentence is a reflection of our inhuman attitude. But such arguments conveniently forget that justice is not only to be done to the accused, but also to the society, but also to the victims. And I am not talking about retributive theory only. When such kind of offenders and such kind of offenses and acts are rarest of rare as defined by the Supreme Court, then in my opinion, no mercy should be shown to such kind of accused persons. And let me now deal with certain Supreme Court judgments in this respect. In Rajendra Prasad versus State of Uttar Pradesh, which is AIR 1979, Supreme Court 916, for all my junior friends. The facts of this case were that the accused and one Ram Bharose were involved in a long-standing family feud. The accused in heat of passion murdered one of the family members of Ram Bharose, for which he was sentenced to life imprisonment. However, after being released from the jail on the occasion of Gandhi Jayanti, he gruesomely murdered Ram Bharose and his friend Mansukh. In this case, the Supreme Court said that death sentence is justified, particularly in those cases where public interest, social defense, and public order warrants. Exemplifying on its position further, the court laid down several tests to decide whether to impose death sentence or life imprisonment. Firstly, the tests that the Supreme Court laid down in that judgment of Rajendra Prasad were: firstly, the death sentence is warranted when due to the crime committed by the accused, the normal life of the community is paralyzed and there is absolute destruction of the social order. That's number one. Secondly, if the accused shows no remorse to the committed crime and is beyond repair within the confines of the prison, then death may be awarded to such an accused. The court in the case of Rajendra Prasad interestingly observed that while sentencing, the court should not give any weightage to the brutality of the crime committed, but should consider the brutality for the evidence as to whether the accused can be reformed or not. So please understand, in Rajendra Prasad, the Supreme Court said that retributive theory, the brutality of the offense is not the only criteria, but what is also to be seen is the non-possibility or possibility of recorrection, reformation of the accused involved in the offense. Thirdly, the motivation of the accused for committing the crime must also be given due weightage. And if the accused committed a cold-blooded murder with absolute planning, then such facts must be considered against him. In the opinion of the court, the motivation of the accused was not the sole criteria, but a relevant one in determining death penalty. And fourthly, the court quoted with approval several of its previous decisions to hold that death sentence may not be preferred if the accused is too young or he is suffering from any kind of economic hardship or mental imbalance, and even if there has been sufficient time gap between the date of commission of the crime and disposal of appeal by the Supreme Court. These were guidelines that were issued, or the tests that the Supreme Court had laid down in 1979. Then thereafter came the judgment, the landmark judgment of Bachchan Singh versus State of Punjab, which is a 1980 Supreme Court judgment, which is a constitutional bench judgment. The Supreme Court in this case, while upholding the constitutional validity of death sentence by a majority of 4-1, held that death sentence can be imposed only in the rarest of rare cases. The court said, while awarding the death sentence, the court will have to take into consideration the aggravating circumstances and the mitigating circumstances, and will have to balance them out while deciding such sentence to inflict upon. Therefore, in the case of Bachchan Singh, the Supreme Court laid down the test of aggravating circumstances and mitigating circumstances while deciding whether to award the sentence of death or not. In Bachchan Singh case, the Supreme Court also said that the court must make a chart and point out which are the aggravating circumstances and then compare it with the mitigating circumstances. And if the court is of the opinion that mitigating circumstances overshadows the aggravating circumstances, then in such a situation, death penalty should not be awarded. So it was a landmark judgment in that sense, because it laid down the test of rarest of rare case and also the test of aggravating and mitigating circumstances, which have to be judged by the trial court or by the appellate court while awarding the sentence of death or while upholding the sentence of death. It is important to remember that under section 354 subclause 3 of the Code of Criminal Procedure, it mandates the judge who is called upon to exercise his discretion between the alternative sentence of death and imprisonment of life to state special reasons for the death sentence that is to be awarded. 354(3) therefore mandates the court who is awarding the death sentence to state the special reasons, and therefore death sentence cannot be awarded in a routine fashion or manner. There has to be special circumstances which must stand out in order to warrant awarding death sentence. The Supreme Court in the case of Bachchan Singh took the liberty to define special reasons as exceptional reasons. In Machi Singh's case, which is again a landmark judgment, the facts which gave rise to the dispute, and I'll state in a nutshell what the facts of that judgment were. In Machi Singh's case, the facts which gave rise to the dispute was that one Machi Singh, along with his 11 other companions, had murdered 17 persons belonging to family of one Amar Singh. There was long-standing animosity and feud between the two families, and Machi Singh sought to revenge and avenge this by killing family members of Amar Singh. As a result of being awarded death sentence by the lower courts, Machi Singh preferred an appeal to the Supreme Court. The Supreme Court in the case of Machi Singh, while upholding the judgment of, while following the judgment of Bachchan Singh, laid down further few additional guidelines. And then the Supreme Court elucidated the point as, firstly, the death penalty should be granted only in the rarest of rare cases. Secondly, while sentencing the accused, the circumstances of the crime and that of the accused both are relevant, and neither of them could be left out from consideration. So the circumstances under which the crime was committed, as well as the circumstances of the accused, have to be kept in mind and consideration while deciding whether to award death sentence or not. Thirdly, Supreme Court also said that the fundamental guiding principle is that death penalty, death sentence is an exception to the general principle of awarding life sentence, and hence it should be used only in extremely sporadic cases, extremely rare cases. It should be seldom used or awarded by the trial court when the facts of that case so require or warrant, and when the trial court is of the opinion that the facts and circumstances are such that except the death penalty, any other punishment would be wholly inadequate. Fourthly, before awarding the death sentence, the sentencing court must draw, as I said earlier, a balance sheet of all the aggravating and mitigating circumstances. And after giving weightage to the mitigating circumstances, if the balance is still tilted in favor of the aggravating circumstances, only then death penalty should be awarded. And apart from enumerating these guidelines which are to be followed, which guidelines are also seen in the judgment of Bachchan Singh, the court in Machi Singh also listed two further questions which must always be answered while deciding on the point of sentence. Firstly, is the offense committed so exceptional, so rare, so exceptional that there is no scope for awarding any other sentence? Secondly, even when weightage is accorded to the mitigating circumstances, does these circumstances still warrant a death penalty? Now, these are the two additional questions apart from those which are listed in the case of Bachchan Singh that a trial court must answer or look into while deciding on the point of sentence in a case which involves imprisonment for life or death sentence. When the court is of the opinion, or when the learned prosecutor is seeking for death sentence, these are the requirements in law that have to be met. Now, often we see that one of the arguments made for abolition of death penalty provision is that there is extreme delay in terms of execution of these sentences. Suppose the man is tried in the year 1990, trial is completed in 1993, he is sentenced to death, his case goes to High Court and then goes to Supreme Court, and by that time suppose 10 years are gone by. And therefore critics of death sentence say that the person under death penalty usually die many deaths waiting for the gallows, as it takes many years for the actual execution to take place after the sentence is awarded by the court. We find in Dhananjay Chatterjee's case, which I'm sure many of you are aware of, where death penalty was imposed on him in the year 1991, and it was confirmed by the Supreme Court in 1994, and eventually he was executed. And all the delay after 1994 till the time he was executed was purely on account of the accused or his relatives, who went on moving the courts after courts, and also the Honorable President of India for the sake of mercy. We have also seen in the case of Nirbhaya that there was a constant back and forth. After the death sentence was awarded, the matter went to High Court, confirmed by High Court. Supreme Court dismissed their appeal. Yet there was curative petition filed. Then there was a clemency petition was made before the President, which got rejected. Again, a petition was filed before the Supreme Court. One after the other petitions were filed before the Honorable Apex Court, and which resulted into natural delay. And therefore, if the delay is due to the acts of the accused or due to acts of the relatives of the accused, it cannot lie in their mouth that now it's been too late in the day to implement or execute the sentence of death, because for so many years it could not have been executed. The answer lies to this is that normally the time that is taken by our judiciary, I understand that there are a lot of pendency of cases, but in a case of death sentence, preference is always given for early hearing of such matters. So as far as our judicial system is concerned, there is no inexorbitant delay in hearing such kind of matters. However, after the sentences are confirmed by the Supreme Court, the manner in which the matter is taken right back to the President and then again to the Supreme Court and again to the constitutional authorities, and the delay that is consumed in this process, only the accused and their relatives are to be solely blamed for this. And what are the remedies for eliminating this delay? I think delay in execution of death penalty can very well be eliminated by different effective remedies, like the President of India or Governor of State may dispose of the mercy petition. And of course, these are my thoughts. The President or the Governor of State shall dispose of the mercy petition within a period of 3 months from the date on which it is received. So mandatory clause of disposal. Second, if the President of the India or the Governor of the state neither allows or rejects such mercy petition within the period of 3 months, then it should be deemed to be rejected, a deeming clause. Third, after rejection of mercy petition, no other petition should be allowed to be entertained either by the Supreme Court or by the Governor or by the President of India again, so that then there is no possibility of going back and forth the way we saw it in Nirbhaya's judgment, Nirbhaya's case. And lastly, after the rejection of the mercy petition, the death sentence should be executed within a period of 1 month. Now, these are some of the changes that we can do in order to take into consideration and curb the menace of this delay, which is always being argued by those who say that death penalty should be abolished. Now, as I said earlier, that it is only in rarest of rare cases that death penalty is awarded, and the trial court or the high court has to make out a special case while awarding death sentence, and there are guidelines and criteria being laid out by the Supreme Court time and again, starting from Machi Singh and several judgments thereafter. Even in Nirbhaya's case, the Supreme Court reiterated the entire law on this aspect, and I need not repeat it. But I think the argument that death penalty should not be there in our statute books is misplaced, because I think that there are several safeguards that are provided in our legal system to avoid any sort of mistake in awarding death penalty. Now I'll come to the provisions of law, which takes a lot of precautions when actually one is being awarded death sentence. Now, what is guaranteed under our constitution is justice according to law. And therefore, when we are talking of the justice, we must necessarily refer to the provisions of law in respect of death penalty. At the outset, I may inform you that every possible precaution, as I said earlier, is taken to see to it that death penalty is not awarded lightly. It is the most complicated surgery of law, and therefore law always takes the help of the best possible surgeons. The first thing, and I'll take you along, or I'll run through the relevant provisions of law, which ensures that death penalty, when the court is faced with the situation of whether to award death penalty or not, there are several safeguards, inbuilt safeguards in the legal system in order to prevent any sort of mistake happening while deciding this sort of punishment. The first thing is that death penalty can be awarded only by the session judge or the additional session judge who have a lot of experience in hearing the trials. This is the first precaution law has taken. Thereafter, please see section 235 of CRPC, which deals with judgments of acquittals or conviction. Now, under section 235 subclause 2 of CRPC, when the accused is convicted, save in cases of admonition or release on good conduct, the judge shall hear the accused on the question of sentence and then pass sentence in accordance with law. Section 235 subclause 2 of CRPC imposes duty on the court to hear the accused on the question of sentence and then pass sentence on him in accordance with law. Section 354 specifies the language and contents of judgment while delivering the judgment in a criminal case. Now, subsection 3 of section 354 deals with judgments where conviction is for an offense punishable with death penalty or in alternative with imprisonment for life. Section 354 subclause 3 mandates that when the conviction is for an offense punishable with death or in the alternative with imprisonment for life or imprisonment for a term of years, the judgment shall state the reasons for the sentence awarded, and in the case of sentence of death, the special reasons for such sentence. The statutory duty to state special reasons under section 354(3) CRPC can be meaningfully carried out only if the hearing on sentence under section 235 subclause 2 CRPC is effective and procedurally fair. To afford an effective opportunity to the accused, the court must hear on the question of sentence to know about 1. Age of the accused, 2. Background of the accused, 3. Prior criminal antecedents, if any, 4. Possibility of reformation, possibility of correction, if any, and other relevant factors that the court may find it necessary. And in such a situation, the defense has to be given an opportunity to lead evidence to show that his client does not deserve any death sentence because the facts under which the offense committed were like this, or because his circumstances of the accused were like this, or because the accused is repentant of what he's done and this is the evidence of his repentance, or because the accused had no criminal antecedents, he does not come from a background which will be an indication that he will not be reformed. Unless such opportunity is given to the defense lawyer on the point of hearing of sentencing, the trial court will be at error in awarding sentence to an accused without hearing the lawyer of the accused on the point of sentencing. This clearly means that unless and until some special reasons exist for awarding death penalty, the said penalty cannot be awarded. Every sessions judge or additional session judge shall have to see whether any special circumstances exists for awarding the death penalty. That is the precaution that the law takes. Thirdly, the further precaution, according to me, is provided under section 366 of CRPC. It is mandated under 366 that whenever any court of sessions awards the sentence of death, the proceeding shall be submitted to the High Court and sentence shall not be executed unless it is confirmed by the High Court. Thus, there is a filter process provided in our Code of Criminal Procedure, which says that if the sentence of death is awarded by the trial court, by the sessions court, it is not to be executed until it is confirmed by the High Court. Now, please see, to all my young lawyers and young law students, even if the accused does not prefer an appeal to the High Court after he being awarded the death sentence, the trial court has to send the paper book to the High Court for the purpose of confirming the sentence of death that is awarded by the trial court. Thus, one can easily find that even though the session judge is at liberty to pass the death sentence, yet the order shall be executable only if and only then when it is confirmed by the division bench of the High Court. Thus, in each and every case, the matter must travel to the High Court even if the accused does not prefer an appeal himself. This is perhaps the highest precaution of humanitarian ground which is taken by the law, a filter system, as I said earlier, that is provided in our Code of Criminal Procedure. Therefore, even if there is some mistake on part of the sessions judge, yet readily that mistake shall be rectified at the higher level. Even after the High Court, if the accused wants, he can go to the Supreme Court of India, even without engaging the advocate if he is financially unable to do so, because there is a legal aid committee which will assist the accused in preferring an appeal to the Supreme Court. And I have also seen that senior advocates appearing pro bono for such kind of accused persons who are awarded death sentence. So it is not as if a sentence of death is handed out to an accused and because he is poor or he has got no financial backup, he would not get a fair representation in courts of law. Well, that is not so. Our system ensures that every accused has a right to be defended. Even in the case of Kasab, let me tell you that he was defended by a battery of lawyers, which were the lawyers provided by the state government at the cost of the state government. We do not have a kangaroo system in existing in India. We have a fair system in India which ensures that every accused gets a fair representation and that there is no miscarriage of justice or injustice done to any accused persons, no matter how grave, how serious the offense he has committed. Then thereafter, the Honorable Supreme Court, if the accused prefers an appeal to the Supreme Court, the Honorable Supreme Court may or may not confirm the death penalty, either given by the High Court or either given by the Sessions Court or by the High Court. So always the Supreme Court is at liberty whether to confirm the death sentence or not. The Supreme Court in a given case may commute the death sentence to life sentence. The further remedy that is left open under Article 72 of the Constitution of India is where the Honorable President of India can be moved for the mercy petition. The Honorable President of India is also supposed to study the matter and then decide and apply the mind whether the death penalty should be condoned or not. And therefore, it is not an empty formality under Article 72, because it is expected that even the Honorable President will look into the fact of the case and will decide whether to grant mercy or not, which is a further filter provided in the constitutional scheme of our legal system. It is clearly mentioned in Article 72, sub-article 1C of the Constitution, that the Honorable President shall have the powers to grant pardon in all cases where the sentence is a sentence of death. By practice, it is expected that the President would ask for a studied opinion of the central government in each and every matter, and then shall decide as to whether the mercy petition should be allowed or not. Therefore, as we see that there are several filters that are provided in our system. Even if an accused is sentenced to death by the trial court, confirmed by the High Court, confirmed by the Supreme Court, the President could, under its powers, the Honorable President could still commute that sentence of death and grant mercy to the accused. And we have seen in several of cases where the Honorable President have condoned the death sentence, commuted the death sentence. Now, when there are so many filters, where from the case of each accused is considered, and it is only after such a heavy exercise of brains and powers, which powers are to be exercised judiciously, that a person is hanged to death. I ask a question to myself, what more should law do? I, for one, always feel that in case the rule of law is to be most effective, then the law must be omnipotent for all the times. The long hand of law should never be cut. Law should never be rendered helpless. In just and suitable cases, in cases which are rarest of rare, in cases which are exceptional in nature, the trial court may, in its discretion, after quoting special reasons, award the sentence of death. And despite that, there are several levels of scrutiny which that sentence has to go through in order to see light of the day. And therefore, in our current legal system, death sentences are not awarded lightly. Death sentences are awarded in extremely rare cases, and with lot of circumspection, those cases actually see the end of the day. And therefore, I submit as a student of law that in our country, looking at the kind of offenses that we see, looking at the kind of depravity that we see, looking at the kind of rarest of rare offenses and cases that we see, when the accused is far from correction, when the accused is far from rehabilitation, when the accused is far from reformation, when the accused shows no remorse, when there is no repentance on his face, and when he enjoys the act that he is committed, the merciless manner in which he has taken lives of people, I believe for such kind of accused persons, death sentence is only an apt punishment. I think with this, I conclude my discussion on the point of death sentence and its jurisprudence. Thank you, LawSikho. It was a pleasure and privilege to be here. to address you all. You all were a fantastic audience, and I wish all the young lawyers out there all the best. Law is an extremely fantastic profession, and I'm sure that you all will shine in your respective field of law and will make your parents proud. Thank you very much.
Thank you, Aniket sir. This was a very, very informative session for me as well. Like I was into infrastructure and projects practice, so I had forgotten my concepts of criminal law, and this was a quick revision of all the precedents you mentioned, and you very beautifully explained the jurisprudence from your perspective. However, as we know, there are always two sides of the
Of
coin.
course.
The side is like I've been getting a lot of messages on the personal chat. I had changed the settings so that you don't get disturbed. There is Vishnu Kale who wants to ask a question. If you're open for a session, because I know you have a meeting at 5 o'clock,
Yeah,
so we'll just
we can
quickly pick two or three questions.
Yes.
Okay, Vishnu, I'm unmuting you. You can directly ask a question. Yes, please go ahead.
Hello, sir. I'm LLB final year student in Maharashtra. I have two questions for you. My first question is regarding the delay in execution of the death punishments. Why there is so much delay in execution of the death punishments? Like in your back case, we saw it took for years and years for the execution of the 4 criminals. And also explain a little bit about the fast track court system. And my second question, sir, one more question. And second question is regarding why there is a different punishment for the murder criminals. For example, some criminals of the murder cases serve life imprisonment and some serve death punishment. For example, Manu Sharma, who murdered a girl, he is serving a life imprisonment. And another case like a Sheena Bora murder case, Indrani Mukherjee is serving as a life imprisonment in the court. And some criminals are served as a direct death punishment. So also tell a little bit about this.
Yes.
Thank you.
Thank you, Vishnu, for your question. You are in your last year of law. I wish you all the luck. And I'm sure you will be a brilliant lawyer once you complete your legal training. Well, Vishnu, to your first question, why there is a delay? Well, ours is a country which has got a huge population and we have got limited resources. And there is absolutely a lot of burden on trial courts, on high courts, and even on Supreme Court. The dockets of the courts are extremely burdened. And in such a situation, it becomes difficult for the courts to manage the docket. And by this, I mean to manage the day-to-day hearing of cases. In cases where the punishment is either life or death, the courts normally give preference for the early hearing of such cases. But delay that happens is not always intentional. At times, it is always also seen that on behalf of the accused persons, an attempt is made to delay the trial, because at the stage of final hearing, it could be argued that since it is at there has been so much of delay, death sentence would further add insult to the injury, and therefore death sentence should not be awarded to them. And Supreme Court in fact has commuted death sentence in several cases on the grounds of delay in execution of death sentences. And therefore, while I was discussing all these issues, I also discussed the remedies for eliminating the delay, and I discussed it in detail, and I will not repeat that. But of course, there are measures to control these kind of delays. And particularly what bothers me is after a sentence is awarded by the trial court and confirmed right up to Supreme Court, and even thereafter when the president dismisses the mercy petition, yet there is a lot of delay in execution thereafter. Now this has to be curtailed. Therefore, I believe that we need a sweeping change in our provisions of law. And when the president has dismissed the mercy petition, then within a limited time frame, the death sentence should be mandatorily executed, is what I think is the need of time. Coming to your second question, you said why there is this disparity in sentencing. Manu Sharma's sentence is serving life sentence, and you cited one more case. I think you cited the example of Indrani Mukherjee, but the trial is still on. Let me tell you, Vishnu, the trial is not over as yet. But yes, there is disparity in sentencing, and therefore the Supreme Court has evolved the guidelines of rarest of rare case, and the courts have to exercise their discretion judiciously and wisely and apply these principles that have been laid down by the Supreme Court in the case of Bachchi Singh as also in the case of Machi Singh, which were reiterated in the case of Nirbhaya by the Supreme Court. And after following those guidelines, the court has to come to a conclusion whether to award the sentence of death or whether to sentence him to life. Now, this disparity is there because we do not have a uniform sentencing policy the way it is there in America. And therefore, again, it's a huge debatable issue to which I'll come on some other point. But of course, there is disparity, but there is a fine line of thought that the Supreme Court has given, which normally the courts have to follow when they have to consider whether to award the death sentence or not.
Okay, so last two questions. One is Sarthak is asking, when does court decide whether a person cannot be reformed any further or not, at which stage? And secondly, there's a student who's asking, what about psychological? I'll just go through it because there are so many questions. I've lost the question. So you can start with this one. I'll scroll.
So the question that is asked is, sorry, I didn't.
When does the judge decide that a person cannot be reformed?
See, when the court is convinced that the accused has committed the offense, the court has to hear the accused, the advocate of the accused, and the prosecution on the point of sentence. At that stage, liberty is given to the prosecution or to the defense to lead their respective evidence to show. The prosecution will attempt to show that he is incorrigible, that he is beyond repair and reforms. The defense will show that that is not so. His past conduct will reflect that he is not so hardly embedded in this criminal world that he cannot be reformed or corrected, and there still lies hope in him, and let us give him one chance so that we do not lose that hope. So it's really a question of evidence which has to be led at the stage of sentencing, and after taking into consideration this aspect, the trial court will then have to arrive at a conclusion whether to award death sentence or not. But as I said earlier, the trial court has to give an opportunity to the prosecution and to defense to lead evidence if they so desire, to decide in order to show that he is not incorrigible, or he is possibly is somebody who could be reformed.
Yes, Samyukhtha, can you ask the question? I'm not able to scroll up. Yeah.
Well, there's just one more question. How do you feel about psychologically affected serial killers or offenders? Should they be should they be cured, or should they be subject to a death penalty?
See, insanity is a defense in criminal law. So it's a very vague term. What do you mean by psychologically affected person? If at the time of committing offense, he was in sound mind and later on he takes the defense of insanity, is not acceptable. Or even if he suppose becomes insane, eventually the court will not award any sentence of death to him. That's a settled law. But the point is, again, we have to go back to the judgment of Bachi Singh and Machi Singh, because it really lays down a formula in that sense. And also it states the circumstances under which an accused could be sentenced to death. And if a man is psychologically unwell, it is for the defense lawyer to show and bring it on record. No court is going to draw a presumption merely because an accused is saying so. There has to be medical tests, there has to be positive evidence in support of that, and only after taking into consideration all this positive evidence, the court will have to arrive at a conclusion.
All right, sir. Sarthak has been willing to ask a lot of questions and he sent me more than 20 messages. Sarthak, I'm unmuting you. You just ask one if you can, because sir has to leave at...
Sammanika, I have to leave at, it's already 4:57, so if we can hurry up.
Okay, Sarthak, just one last question. Please go ahead.
Oh, yes. Hello, sir. Can you hear me?
Yes, Sarthak, you sound to be an intelligent man. A lot of
okay, thank you so much. Okay, so my last question is, since you're talking about the case of Bachchan Singh a lot, I just wanted to ask you, do you think there's any possibility that the formula that has been given in the Bachchan Singh case, is there a possibility that these guidelines are a little bit outdated? Because the kind of society that we had at that time compared to the problems that people face today that lead them to, commit such crimes, there'll be like slight variations. So do you think we need to work upon these guidelines, or can we still go
for this? I would answer, Sarthak, you must read the judgment of Nirbhaya, because in Nirbhaya, Honorable Supreme Court referred to the Constitution Bench judgment of Bachchan Singh, which is still the law of the land, which has not been overruled. And I don't think it is outdated in any manner, because Supreme Court laid down guidelines It's not a straitjacket formula that the Supreme Court has given to all the courts. These are the guidelines which have to be adhered to in the interest of justice and also in the interest of accused persons. So what the Supreme Court says is that it has to be an exceptional case. There has to be something else than normal case. It's not about the brutality of offense per se, but the Supreme Court also said that all the surrounding circumstances must be kept in mind before the trial court really entertains the thought of awarding the death sentence. So it's not an outdated judgment. It is still extremely valid. The Supreme Court is still following it. It is a constitution bench judgment which has not been overruled or set aside by any future judgments.
Okay, thank you so much, sir.
Thank you everybody.
Sahil instead of Sarthak, I got confused between both the names. Sahil is requesting, would you be able to, or will you, can he write you on email his queries? Because
yes, of course he could. Of course he could email it to me. No problem, Sarthak.
Okay, sir. Sir, could you share your email address?
Aniket.nikam@gmail.com. aniket.nikam@gmail.com.
Okay, Sahil, we request you, and we are really sorry we couldn't discuss your questions. Please directly ask the questions from sir. And thank you so much, sir. Once again, thank you, Samyukhtha, for your time. And I would request the participants to kindly rate this session, 0 being the lowest, 10 being the highest, so that we get to know whether you were able to benefit from the session or not. Yes, in the chat box, you can write your review. Most of them are sending me messages privately, 8, 10, 10, 8. All right, sir. Thank you so much. You may leave the meeting. I'll.
Thank you, Sammanika. Thank you, LawSikho. Thank you very much. I hope everybody has sikhaud something.
Definitely.
Bye-bye.